Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer. A problem that brokers often have to confront is a situation where a buyer spouse, so a married buyer, is purchasing in their separate estate for whatever reason. For some reason, the buyer has a spouse who's not going to be on title. It could be a credit issue. It could be any number of reasons why. But just assume for a moment that the buyer is closing the transaction or intending to close the transaction in the absence of their spouse, or at least in the absence of their spouse's name being on title. And so the question comes from a listing broker who says, how do I protect my seller to make sure that we don't get to the closing table with everything else being taken care of, but all of a sudden we have this non-buying spouse creating a problem for the closing? How would that create a problem for the closing? If the buyer is getting financing, the buyer's lender will require the buyer to sign a deed of trust, giving the lender security in the title to the property. Everybody who owns the property must sign that deed of trust. So if a married buyer is taking title to the property, let's just say John Doe is the married buyer taking title to the property, and John Doe is married to Jane Doe, and Jane Doe's not going to be on title. So John Doe's taking title, signs a deed of trust, and the lender discovers that John Doe is married to Jane Doe. Is the lender going to let that transaction close as is? The answer to the question is no, they're not. Why not? Because Washington is a community property state. So when John Doe takes title to real property, Jane Doe automatically has, at least arguably, a marital lien on title to that property. So even though Jane Doe's name doesn't appear on title of the property, Jane Doe has an interest in that property. This will come up often in the context of spouses who are in the process of divorcing, but they're not yet divorced, and John wants to go ahead and buy the property before the divorce is final. That doesn't work unless we're going to do something with Jane's interest in title to the property. So the question then is, as a listing broker, how do I protect my seller to make sure that the married spouse purchasing the property in their own name without including the other spouse, how can I ensure that I don't have a problem at closing? Listing brokers. Let me tell you what has to ultimately happen, and then we'll talk about how you're going to get there. What ultimately has to happen is that Jane Doe needs to sign a quitclaim deed, releasing any interest that she has now or will have in the future with respect to title to that property. It's just a standard quitclaim deed. When Jane Doe signs that quitclaim deed, delivers it to the title company can record that simultaneously with the closing, relinquishing any interest that Jane may have now or in the future entitled to that property, giving John Doe, in our case, the exclusive right to sign that deed of trust, securing the lender's interest in the property. Title company's happy, lender is happy. Listing broker, how do you make sure at the time of mutual acceptance that Jane Doe is going to sign that quitclaim deed at closing? And the answer is you don't. You don't wait until closing to make this happen. Listing brokers, you create a provision in the purchase and sale agreement requiring John Doe, the buyer, to provide to the seller within a specified number of days, and it shouldn't be a whole bunch, 3, 4, 5, how long does the seller want to have the house off the market? That John Doe provide to the seller a quitclaim deed signed by Jane Doe, relinquishing Jane Doe's interest in seller's property. Signed, dated, notarized. And if John Doe doesn't timely deliver that quitclaim deed to seller should preserve to themselves the right to terminate the agreement and put the property back on the market. In other words, seller is going to create a contingency around John Doe's delivery of Jane Doe's quitclaim deed. Now, if the spouses are cooperating on this transaction, there's no marital discord, just for whatever reason, John is going to be the only buyer, then probably it should be easy to get that quitclaim deed. You probably might have to go to a lawyer to get it drafted, unless you can find somebody who will draft one for you. Escrow won't, title won't. Lawyers, real estate brokers aren't licensed to draft a quitclaim deed. They're not complicated documents, but you're going to have to find somebody to prepare one for you. But assuming that Jane Doe signs that, gets it delivered to seller or to escrow, then the transaction can proceed to closing. If Jane Doe does not sign that quitclaim deed timely and get it delivered through buyer to the seller to escrow, then seller could terminate the transaction. The question that usually comes up in class when I talk about this is brokers asking, how on earth can Jane Doe sign a quitclaim deed for property that John Doe doesn't even yet own, that she doesn't have any interest in yet? Understand that a quitclaim deed simply relinquishes any right to title in this property that I have now or may have in the future. But if I have no title to the property, then by signing the quitclaim deed, I'm not giving anything away that I don't have. I often use the example that I could sign a quitclaim deed giving anybody watching this video title to the London Bridge. Why? Because the quitclaim deed only conveys interest that I hold. I don't hold any interest in the London Bridge, so if I signed a quitclaim deed for the London Bridge and gave that to you, I would be giving you nothing. But if in the future I acquired ownership of the London Bridge, you would then have title to the London Bridge through my quitclaim deed. That's how this works in this scenario. So sellers, listing brokers, this isn't something that comes up very often. We do not have a boilerplate provision around this issue because it is fairly unique, but it comes up often enough that I get questions on the hotline about it. If you need to document this issue, you're going to have to write a contingency for the seller requiring the buying spouse to deliver a quitclaim deed signed and notarized by the non-buying spouse within a specified number of days to the seller or to escrow so that it can be recorded at closing. If you have a question on this topic or any other, please send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.